one of the things we saw during the Uvalde school shooting incident was the response of the police officers. And I'm not here to comment on what's true and what's not about their response. But the accusation is that the police officers from some local municipality, whether it be Uvalde or something related to the school, that they did not respond in a timely manner. They arrived at the school in a kind of timely manner, but did not engage the attacker, the Ramos, in a timely manner. And that is certainly a valid accusation. One of the claims that is often made in lawsuits and in legal threats is that the police have some kind of duty to respond, duty to engage, duty to respond. How can they just sit there in the parking lot or sit there outside the room, the classroom where Ramos has barricaded himself? How can they just do that? Is that legal? How can that be legal? And that's what I wanted to talk about today, was the special duty of care, or the general duty of care, associated with, well, really anybody, but also associated with police officers. Yeah, we do have to be careful not to hindsight is 2020 Monday morning quarterback this situation. I have sympathy for both the police who didn't want to, for whatever reason, weren't ready to engage the attacker. And I also have sympathy for the parents and victims and students who want to be rescued as soon as possible. Today, I thought we would discuss the sort of philosophy behind that belief or social contract, social policy that police have no affirmative duty to protect in general. The terminology we're going to use is general duty to protect versus special duty to protect. We're not going to need that terminology all the time, but you will see it referred to as police needing to have a special duty to protect, which the way you get that duty, we're going to discuss that too. You don't have automatically, you don't have a special duty to protect. You don't automatically have a general duty to protect. So you can acquire a special duty to protect under circumstances. Like the easy one with police is custody. If the police take you into their custody, then they do have a duty to protect you. They do have a duty to care for you on some level. It's probably a reasonable police officer in that situation or something. It's not like they have to be Iron Man and stop all bullets or something. But it's not like the police have a general duty to respond to all 911 calls and prevent all injuries. They also don't have a duty to respond to all 911 calls and attempt to prevent all injuries. They don't even have a duty to respond to all 911 calls. A duty to protect or a duty of care can be created by statute or by law. So a local municipality or a county or a state or the federal government, within their jurisdictional powers, they could create a law that says police have some kind of affirmative duty of care. But that's not the way it's done now. As a rule, one has no duty to come to the aid of another. A person who has not created a peril is not liable in tort merely for failure to take affirmative action to assist or protect another, unless there is some special relationship between them, which gives rise to a duty to act. So, like, if I'm a parent and I have my child in my custody, and the child falls down the hill and rolls into the river, like I almost rode my bike into the river yesterday after I tried to touch my wife's shoulder while we were riding side by side, and then I caught my handlebar on her handlebar, and then I almost went into the river. If my child did that, I would have an affirmative or special duty of care to help my child, Even if I didn't create the situation, I have a special relationship with that child. I'm the child's custodial parent in that hypothetical. That's where you get a special duty of care. Now, if I'm riding along and I see someone else's child go into the river, in America, you generally don't have a duty of care to someone else's child. If I am a police officer and 911 call comes in that there is a child drowning in the river, that police officer should respond. I think we can universally agree the police officer should respond, or the police force or the dispatcher should dispatch someone, and that person should go rescue the child from the river. But if the police officer doesn't, for some reason, doesn't get dispatched, doesn't actually goes but doesn't actually do anything, goes and tries to help but fails, or worse, makes the situation worse than it was, those situations don't necessarily give rise to a duty of care where that failure can be recovered, where you can have justice in a court of law from your failure to act, from the police's failure to act. There is a line, and I want to go over that today. And actually, the case that I really like for this is the Williams versus the state of California case. Let me pull it up here. So I don't know how good this law is. So don't cite my video as evidence of this case still being good. But this is Della Williams versus the state of California. And the court here, the California Supreme Court, does a pretty good job of spelling out the special duty of care that police officers need. The issue in this case, so we were all the way up to the California Supreme Court, is whether the mere fact that a highway patrolman comes to the aid of an injured or stranded motorist creates an affirmative duty to secure information or preserve evidence for civil litigation between the motorist and third parties. So in this case, a police officer responds, and that response was somehow inadequate. They did not preserve evidence for future civil litigation between the parties that are victims in the accident. We find that stopping to aid a motorist does not in itself create a special relationship which would give rise to such a duty. According to plaintiff's complaint, she was a passenger in an automobile on a bridge crossing the American River in Sacramento when a piece of a heated brake drum from a passing truck was propelled through the windshield and struck her in the face before coming to rest on the rear seat of the automobile. The complaint also alleges that defendants, the state of California, and does 1 through 5, I'm thinking that those are police officers, each of them arrived within minutes of the accident and assumed the responsibility of investigating the accident and the accident of 2 other vehicles which were damaged and stopped at the scene to determine the causes thereof. And, the complaint said, defendants so negligently and carelessly investigated the accident as to virtually destroy any opportunity on plaintiff's part to obtain compensation for the severe injuries and damages she suffered from any other defendants or any other persons who concurred in causing them. Included amongst said acts of negligence was the failure to investigate the brake drum part to determine it was still hot, failure to identify other witnesses at the scene, or even the other motorists damaged by brake drums, and failure to attempt any investigation or pursuit of the owner or operator of the truck whose brake drum broke and caused plaintiff's injury. The state moved for judgment on the pleadings on the grounds that the police function in investigation of accidents is immune under specific immunity statutes and under general governmental immunity for discretionary acts. The trial court granted the motion, finding the state is immune and refusing to apply what it called a special relationship exception to statutory immunity. We turn first to the question of duty under general principles of tort law. As a rule, one has no duty to come to the aid of another. A person who has not created a peril is not liable in tort merely for failure to take affirmative action to assist or protect another, unless there is some relationship between them which gives rise to a duty to act. So again, this is the general duty to act. You can easily have a special duty to act. Kaylee, for example, is a first responder, and in Luxembourg, if she sees a situation that she can respond to, then she has a duty to make that response. She's not allowed to just stand by and watch. She has to call, or she has to begin first aid or something like that. She has that special relationship. But generally speaking, you don't in the US. This varies from state to state, so this is not legal advice, but you generally don't have an automatic duty to come to the aid of another. Also pertinent to our discussion is the role of the volunteer, who, having no initial duty to do so, undertakes to come to the aid of another, the Good Samaritan. He is under a duty to exercise due care in performance and is liable if A, his failure to exercise such care increases the risk of such harm, or B, the harm is suffered because of the other's reliance upon the undertaking. Application of these general principles in the area of law enforcement and other police activities has produced some confusion and conflict. To an extent, the concepts are muddled by widely held misconceptions concerning the duty owed by police to individual members of the general public. In spite of the fact that our tax dollars support public functions, it is settled that the rule concerning the duty, or lack thereof, to come to the aid of another are applicable to law enforcement personnel in carrying out routine traffic investigations. Thus, the State Highway Patrol has the right, but not the duty, to investigate accidents, or to come to the aid of stranded motorists. Nevertheless, although no special relationship may exist between members of the California Highway Patrol and the motoring public generally, or between the patrol and stranded motorists generally, when the state, through its agents, voluntarily assumes a protective duty towards a certain member of the public and undertakes action on behalf of that member, thereby inducing reliance, it is held to the same standard of care as a private person or organization. The breach of duty may be an affirmative act which places the person in peril or increases the risk of harm. See McCorkle versus Los Angeles, where an officer investigating an accident directed the plaintiff to follow him into the middle of an intersection where the plaintiff was hit by another car. The negligence may also constitute an omission or failure to act, such as in Morgan versus County of Yuba, where a deputy sheriff promised to warn a decedent if a prisoner who had made threats on her life was released. The county was held liable when the sheriff failed to warn. Recovery has been denied, however, for injuries caused by the failure of police personnel to respond to requests for assistance, the failure to investigate properly, or the failure to investigate at all, where the police had not induced reliance on a promise, express or implied, that they would provide protection. See Hartzler, police failed to respond to a plea made 45 minutes before a homicide. Antique Arts Corp., police radio dispatcher delayed 10 minutes after alert before broadcasting about a burglary in progress. McCarthy, complaint alleged decedent was driving on a state highway at a particular time and place. Highway Patrol negligently failed to find him, and death was caused by failure to receive timely medical aid, and the court held the state and the patrolman were not liable. This does not mean that a promise and reliance thereon are indispensable elements of a special relationship. Such relationship has also been found when the conduct of a police officer in a situation of dependency results in detrimental reliance on him for protection. A special relationship based on such dependency was found in Mann v. State of California. Highway patrolmen coming to the aid of a stranded motorist placed their car with flashing lights between two cars stalled on the freeway. After calling the tow truck, the officers withdrew without warning. They did not wait for the tow truck to line up behind the stalled car or provide the alternative protection of road flares. Minutes later, the stalled car was sideswiped by a passing car and the persons nearby were injured. In Man, the officer's conduct contributed to, increased, and changed the risk which would have otherwise existed. They stopped to investigate, and they took affirmative steps to provide assistance, lulling the injured parties into a false sense of security and perhaps preventing other assistance from being sought. Although the legislature viewed Man as dangerously extending the liability of peace officers while engaged in activities not involving law enforcement, i.e., while rendering assistance to stranded motorists not involved in accidents, the case is no more than the application of the duty of care attaching to any volunteered assistance. Indeed, in Davidson v. City of Westminster, we held that Man, properly read, is a simple application of the Good Samaritan doctrine, to extend the Man situation where the officer had undertaken to protect the plaintiff from future physical harm, to the one presented here, failure to investigate the cause and source of harm already incurred, is, however, quite unwarranted. Students of the Bible will recall that while the Samaritan dressed the victim's wounds and provided him with food and shelter, he took no steps to ascertain the identity of the thieves who had wounded and stripped the victim and left him half dead. Nevertheless, see Clementi versus State of California, which followed and purported to be controlled by Man, and that does impose such an expanded duty on peace officers. The complaint in Clementi alleged that a highway patrolman stopped to investigate an accident in which a motorcyclist allegedly struck a pedestrian in the crosswalk. The officer cleared the site of the accident of traffic and questioned the witnesses. The cyclist admitted that his machine had struck the pedestrian, but denied responsibility. The officer radioed for an ambulance, notified the city police, but did not obtain the identity of the motorcyclist who had departed when the city police arrived. It is important to note that it was not alleged that the officer's investigation caused plaintiff not to undertake one of his own. Nevertheless, the Court of Appeals found potential liability against the state based on the officer's alleged negligence in failing to get the cyclist's name. It read its own decision in Man as establishing a special relationship and thus a duty to act based solely on the fact of dependence. Finding the pedestrian dependent on the highway patrolman, the Clementi court imposed liability where the patrolman's acts consisted of stopping to investigate and failing to secure the cyclist's name. Yet on similar facts, the Court of Appeals in Winkleman versus City of Sunnyvale had found no special relationship giving rise to a duty to assemble evidence for future civil litigation. Plaintiff was driving on a freeway when struck from behind by a pickup truck, which pushed her car across the freeway into oncoming traffic and a collision with another car. Both drivers were badly injured and were unconscious when the city police arrived to investigate. Meanwhile, the driver of the pickup stopped at the city police station and reported that he might have been a participant in a freeway accident, but was allowed to leave because the police had not yet learned that a pickup truck had been involved. Plaintiff based her suit on the city's alleged negligence in permitting the driver of the truck to leave without securing identification, claiming that she suffered damage in the frustration of a valid cause of action for her injuries. Responding to plaintiff's argument in Winkleman that a duty to exercise due care arose when the officers voluntarily undertook to investigate the accident, the Court of Appeal reasoned that the detriment suffered by plaintiff by reason of the involvement of the truck occurred before the officers arrived, and the claimed negligence on their part was the failure to protect her from the effects of events that had already happened. Since the officers had not created the peril, they were under no duty to take affirmative action unless a relationship existed between them giving rise to the duty. The Court of Appeal found no such relationship. Obviously, Winkleman and Clementi are irreconcilable. Turning to the case before us, the sum and substance of plaintiff's complaint is that unnamed agents of the state arrived within minutes of the accident and assumed the responsibility of investigating the accident. The alleged negligence is nonfeasance, the failure to test for the heat of the object which struck her, failure to secure identification of witnesses, failure to attempt investigation or pursuit of the owner or occupant of the truck whose brake drum had caused her injuries. There are no allegations that the officers assured her, either expressly or impliedly, that they would do any of the acts she faults them for not doing. no allegations that they conducted themselves in such manner as to warrant reliance upon them to do the acts which plaintiff alleges they should have done, nor finally is there any hint that they prevented plaintiff from conducting an investigation of her own. Applying the general principles of law represented in the decisions reviewed above from McGorkle to Mann, we conclude that plaintiff has not stated a cause of action in that she fails to establish a duty of care owed by defendant state. The officers did not create the peril in which plaintiff found herself. They took no affirmative action which contributed to, increased, or changed the risk which would have otherwise existed. There is no indication that they voluntarily assumed any responsibility to protect plaintiff's prospects for recovery by civil litigation, and there are no allegations of the requisite factors to a finding of special relationship, namely detrimental reliance by the plaintiff on the officer's conduct, statements made by them which induced a false sense of security and thereby worsened her position. So then the question in the Uvalde, or should I say Robb Elementary School situation, the question becomes, did the Uvalde Police Department have some sort of special duty of care? And I think the answer is not at first. When 911 calls went out, when the initial engagement of police with the attacker happened, I'm not sure if there was any sort of affirmative or special duty of care at that time. Now, at some point, there could be special duties of care that come into the situation when the police arrive and they lock down the situation and they've got a perimeter and they've secured the scene of the ongoing crime. There is some level of a special duty of care there. In these cases that we just read, all of these examples, these people were not prevented from investigating their own situation, these motor vehicle accidents. Well, in the Uvalde Robb Elementary School situation, police prevented parents from going inside and getting their children. Now, that's normal. You would normally prevent parents from just going and getting children. They'd have to go through a check-in, check-out process or something. So it's normal to secure a crime scene and not let people go in and out of a crime scene. It's also a matter of valid debate what tactics and strategy the police are supposed to use. I'm not taking a position on whether the police in the Robb Elementary School situation should have gone in immediately or waited 10 minutes or waited half an hour or whatever they did. The question for me today is whether they had a duty to do that. And one of the reasons we don't have these complicated duties where not only the police have to show up, but they then have to investigate. That investigation has to be of a certain level of quality. The outcome has to be top-notch or high-quality outcome or something like that, is because of the complicated nature of that. Imagine you go back to this example of the Williams versus State of California situation. The police respond to a multi-vehicle car collision on the highway, and they focus on people's injuries, and they don't get a plate number of the cause of the accident. They don't get the driver who caused everything and injured so many people and caused so much damage and destruction, drove away or something like that. And the police didn't get the guy's identity, even though they had every opportunity to do so. Well, where do you start second guessing the police? Like, where's the valid place to start second guessing? Should they have gotten identities first and tended to people's injuries second? Should they tend to injuries first and risk losing the identity by tending to it second? And all of the arguments that stem from that situation. So it is a complicated thing to start imposing duties of care on people and police officers for how they handle and how they respond. So not only is it complicated whether they respond, whether they have a duty of care at all, yes or no, now it's also complicated what is that duty of care? What is the level of that duty of care? Usually we use the reasonable person standard, And the reasonable person standard is a shifting standard. It will depend on the context of the situation. So in police responding to a school shooting, I would say we use the standard of a reasonable police officer responding to a school shooting. And I'm going to guess that while I think there will be a lot of social backlash, I'm not sure if there was a violation of any duty of care legally in the Uvalde situation. I'm not saying, again, I'm not saying the police responded properly. I'm saying that I don't think that their response was illegal. And if we want that to change, if you want there to be a affirmative duty for police to engage with a school shooter as soon as possible, I think that needs to be done by the legislature. I think that would need to be something that's codified into law that says here are the rules of engagement. If you are a police officer employed by this municipality or this county or this state or federal or whatever, and you encounter a elementary school shooting or whatever, then you have an affirmative duty to engage immediately to do everything to stop that. And then the counter argument will be, well, that doesn't account for the live nature of tactical and strategic situations. We're going to encounter a situation where it's good to wait, and then somebody's going to go in early and someone's going to die because they went in early, and we're going to have the exact opposite situation eventually. I mean, hopefully not, of course, but given the number of these things that we get, legally that hypothetical sounds like it's going to come up eventually. I also found an article by Karen M. Richards for the NYSBA Municipal Lawyer, Summer 2013, Volume 27, Number 2. In her article, she's talking about municipalities, and a police department is a municipality, so that works. When a municipality provides police protection, it is performing a classic governmental function requiring a legislative, executive decision as to how the municipality's resources should be allocated. For example, if injuries arise from the municipality's failure to supply adequate police protection, unless there exists a special relationship between the municipality and the injured party, the courts have never imposed general liability simply from the failure to supply adequate police protection. This conclusion stems from recognition that municipal resources are limited, and the duty to provide police protection ordinarily is owed to the general public and not to a particular individual or class of individuals. To establish a special relationship, the plaintiff has a burden of proving an assumption by the municipality of an affirmative duty to act on behalf of the party who was injured, knowledge by the municipality's agents that inaction could lead to harm, so that's knowledge, some form of direct contact between the agents and the injured party, so direct contact, and the injured party's justifiable reliance. So this is justifiable reliance on the municipality's affirmative undertaking. All four must be proven. Then she goes through some examples here. In Lance v. State, Anthony McIntosh was released from prison and was on parole. He allegedly threatened the life of his wife and subsequently murdered her. The claimants, the administrators of Mrs. McIntosh's estate, claimed that prior to her death, Ms. McIntosh had relayed the threats to a parole officer, and that, after receiving notice of the threat, the state of New York was negligent in failing to immediately attempt to apprehend Mr. McIntosh, in failing to take him into custody, and in failing to place her under protection. The claimants could not demonstrate that the state had an affirmative duty to act because the parole officer's statements were not definitive promises to take actions to protect Mrs. McIntosh. The parole officer had told Mrs. McIntosh that if Anthony McIntosh appeared as scheduled, he would be questioned, and based upon his responses, he may either be taken into custody or given a parole condition ordering him to stay away from her residence. The court found these statements were of a highly contingent nature, and therefore, the claimants had not demonstrated the assumption of an affirmative duty to act. In D'Amato v. City of New York, the plaintiffs claimed the police made two statements promising to provide them with protection from gang members. Several days before a confrontation outside his home with a gang of youths, D'Amato had reported to a community affairs officer at the precinct that a gang had attacked his son several times. The officer informed him that there was a shortage of manpower, but he would see if he could get a patrol in that area. On the day of the confrontation with the gang, but before it occurred, the police responded to a 911 call placed by D'Amato. The responding officer told D'Amato that a patrol car would be kept in the area, not to worry about it, to call 911, and they would get there right away. The court ruled that these statements did not create a special relationship because the police did not promise to keep watch at the plaintiff's home and did not specify at what time or for how long they would keep a patrol car in the area. The court opined, at most, the police assured plaintiff that they would respond to a 911 call, an obligation that is owed to the public at large. An assurance to perform a basic police function without more does not amount to a promise to act affirmatively on behalf of plaintiff. In Swift v. City of Syracuse, a 4-year-old child who had been left by her mother in her maternal grandmother's care for the evening was taken from the grandmother's house by her father. There was no custody order in effect, and the child's parents were not married and were not living together. 2 police officers responded within minutes after being dispatched by 911, but one left shortly thereafter because he deemed the situation to require only one officer. The grandmother told the remaining officer that she was concerned for the child's welfare and believed the father was intoxicated. She gave 3 possible locations where the father might have taken the child. The officer began checking 2 of the locations given to him by the grandmother, but before he could check the 3rd location, he suspended his search to investigate a separate assault complaint. An hour after the grandmother's call to 911, the officer was called to a fire at the 3rd location, where, as it turned out, the father had taken the child. The fire resulted in a fatality, and although the father and the child escaped, the child suffered serious and disfiguring burns. The 4th Department affirmed the lower court's grant for summary judgment to the city because the plaintiff had failed to raise an issue of fact as to whether the police had knowledge that their inaction would lead to harm to the child. Significantly, the grandmother assured the officer that the father loved his daughter and would do nothing to harm her. In Escribano versus Town of Haverstraw, a police officer had observed a swerving vehicle being operated by Mr. Escribano. The police officer stopped Mr. Escribano's vehicle and issued him a ticket for a seatbelt violation. Shortly after being stopped and ticketed, Mr. Escribano crashed the car and his son, a passenger, was killed. Plaintiffs allege that as a result of the investigative stop, the officer had knowledge that Mr. Escribano was experiencing diabetic shock, and thus the defendants owed a special duty of care to the plaintiffs. The court disagreed, finding that there was no indication that the officer had knowledge that any inaction on his part could lead to harm because the record was devoid of any evidence that he was aware of Mr. Escribano's diabetic shock. In Ewell versus Incorporated Village of Hempstead, when police responded to the home of the plaintiff's mother, she advised them that her son suffered from a mental illness and had ingested an entire bottle of pills. After the officers unsuccessfully attempted to restrain the plaintiff by administering electroshock with a taser 3 times, the plaintiff escaped to his bedroom and set it on fire. The court found that the direct contact between the police and the plaintiff was not of a kind that meaningfully alerted them to his intent to set fire to his room, and there was no basis for the police to have realized that their failure to move more expeditiously or violently to detain the plaintiff could lead to the harm that occurred. In Thomas versus City of Auburn, a bar patron, Jimmy Lee Rouse, had engaged in an altercation with 2 other patrons, Thomas and Tillman, and threatened to kill them. The bartender, Reddick, called the police, who responded to the bar and who were told of the death threat when they interviewed Reddick, Thomas, and Tillman. The officers assured the 3 men that they could finish boarding a window broken in the altercation and could finish closing the bar. The officers also told the men that they would go around the building and escort them home. The court found these statements were sufficient for the jury to have found the officers assured the 3 men of having police protection, thus establishing justifiable reliance. In that case, there was no dispute that the police officers made assurances to the bartender, but there was conflicting testimony as to whether the officers made assurance of protection to Thomas and Tillman, who had been threatened by Rouse. When Rouse was escorted from the bar, but before leaving in a car, he threatened he would be back. The defendants contended that Thomas and Tillman were inside the bar when the assurance of protection was made to the bartender outside. Thomas admitted that he did not hear the officer's assurance, but he testified that when the bartender came back inside, he told Thomas that he and Tillman could remain at the bar because we was being protected. Without advising the men that they were leaving, the officers left the scene to search for Rouse's vehicle, and while they were searching, Rouse returned to the bar and fired a shotgun, injuring Thomas and killing Tillman. The court found that, even assuming that both Thomas and Tillman were inside the bar when the assurance of protection was made to the bartender outside, the assurance was extended to all three men, and the circumstances were such that the officer who gave the assurance knew, or should have known, that it would be conveyed to Thomas and Tillman. In Hanna v. St. Lawrence County, Andrew Longshore physically assaulted the plaintiff, his live-in girlfriend, held her hostage for several hours, and threatened to kill her. After the incident, the plaintiff sought refuge in friends' houses for over a week before returning to her home. Following Longshore's release from jail, when the plaintiff advised county deputies that there were many guns in Longshore's grandmother's house, where he was under house arrest, the deputies told the plaintiff that the house had been searched and all weapons had been removed. When she expressed concern that the grandmother's house was in close proximity to her own home, she was told by deputies that it's not an issue, you're safe. She was also repeatedly advised that there was no way that Longshore could come after her because of the electric monitoring device that had been placed on his ankle. These statements reassured the plaintiff and eventually convinced her that she was safe. The court therefore denied the defendant's motion for summary judgment. It found that a question of fact existed as to whether the deputies' assurances lulled the plaintiff into a false sense of security and induced her to relax her own vigilance and forgo other avenues of protection, such as relocating to a safe house or to a different residence as she had done immediately after the attack. It doesn't say what happened to her. I'm assuming that she got attacked or something. I hope she was okay. The fourth element was also missing in Grieshaber versus City of Albany, because the decedent was already being attacked when she called 911. The 911 operator who told the victim that help was on the way could hear scuffling noises and the decedent screaming to someone in the room to get out. The record undeniably revealed that the decedent was struggling with her assailant before, during, and after the call, and therefore her conversation with the 911 operator did not induce her either to relax her own vigilance or to forego other available avenues of protection. The third department regrettably reversed the lower court's order and granted summary judgment in favor of the city and dismissed the complaint. And Ms. Richards concludes here that determining whether a special relationship exists is intensively fact-based. Unless a plaintiff proves the existence of all four elements necessary to establish a special relationship, there is no recovery against a municipality for injuries sustained when a municipality fails to furnish adequate police protection. So, if we wanted to go back up here and look at these elements and apply them to the Uvalde Police Department's behavior, totally hypothetically and allegedly, here's what they were again. An assumption of the municipality through promises or actions, or I'm going to add through a legal duty, of an affirmative duty to act on behalf of the party. So we're looking for the Uvalde Police Departments, for lack of a better phrase, whatever they called themselves. Did they assume an affirmative duty to act on behalf of the party who was injured? Maybe at some point, I believe not initially. So when the initial call goes out and the police respond and they arrive on scene, at some point in there, I feel like they've assumed some duty to act on behalf of the victims, the school, the students, the teachers, the victims of the attacker who have called for the police's help. Looking at these cases, I'm not sure that the police had enough control of the situation to be held responsible for the lives of the people in the classroom. the teachers and the children. Let's take a look at number 2. Knowledge on the part of the municipality's agents that inaction could lead to harm. Okay, that one's pretty easy. I think they did have knowledge that if they did not act, that this would lead to harm. It's not, the harm isn't going to be caused by the municipality, by the police, but not acting means that the gunman could cause more harm, and it seems like he did. 3, some form of direct contact between the municipality's agents and the injured party. I mean, I guess that's going to be the phone call, the 911 calls, and those people would be then relying. Well, let's get to number 4 because that's the justifiable reliance one. So direct contact would be the 911 call, I think. And number 4 is the justifiable reliance on the municipality's affirmative undertaking. And remember, this was detrimental, justified reliance. That someone would maybe not investigate their own car accident because, oh, the police are going to do that. That maybe someone would not run away from an attacker because, oh, the police are here, they're going to take care of the attacker. So was there a justified reliance on the people trapped, barricaded in that classroom, that the police were going to take care of it and they didn't have to do anything more for themselves? It was a really hot situation, right? The students were in the middle of being killed in the classroom, like over a period of time. What else were they going to do? They were not foregoing other action. They were not foregoing escape. They did not have anything else to do. It was a horrible situation. It was a horrible outcome. I'm not minimizing and discounting that, but trying to look at it clinically here, that little girl that kept calling 911 over and over again from the classroom, was she justifiably relying on an affirmative duty by police? I don't think so. Maybe police had an affirmative duty to act, but do we really get into the territory where we get to start criticizing that action, that the action, they responded and they waited too long, and therefore that inaction rose to some level of negligence that is actionable under the law? That's the question, and that's the question we don't have an answer to. It's not clear in this case. It's not clear to me. So let's have the debate in the comments below whether the police created an affirmative duty at some point. They either had an affirmative duty under the law or they created one at some point by taking over the crime scene or something. Now, I say that they didn't have control of the crime scene, even during the period of time they're waiting, the 80 minutes, I think it was, that the attack went on. Knowledge that there would be harm, yeah, that I think you've got that element, but you need all 4. Direct contact between the agents and the injured parties, and we said that it didn't need to be that the police told each individual person. It was enough to tell the one, knowing that they would tell the others. So I think, you know, somebody in the classroom calling for 911, I think that's enough to establish that one. So is there an affirmative duty, and was there justifiable reliance? So even if there was an affirmative duty, even if the police did assume responsibility, liability for the crime scene, were the parties in the classroom that were victims of Ramos justifiably relying on the police to their detriment, that they relied on the police, and because they relied on the police, that they were the ones that were killed? They could have escaped, except that they expected the police to rush in a lot earlier. I think that's the argument. Let me know if you have a different argument, better argument, counter argument. Let me know what you think in the comments below. Let's try to keep it about the duty of care and not about other things. Like, I understand there's a gun control debate and everything and all wrapped up in this. Let's try to keep it about the duty of care, exploring the legal philosophy behind this. Let me know what you think in the comments below. Thanks for watching! Special thanks to my top supporters in May: John Steele, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, Gutbrodj, ShadowTycho, Earthbound Star, PureMagma, Eric Tams, TechTechPotato, The Blood-Soaked Survivors, Wyatt Calandro, and King Aries. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for my weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye.